I know so many of you are still loading in. We have quite a few participants today. Thank you for joining the CLE. For those of you who are new to the Procrastinator series, welcome. This is our second event in the third event in the Procrastinator series. We are really honored today to feature the CAP Consumer Assistance Program, uh, a tremendous resource of the bar that I suspect so many of you may not be aware of. And that's the purpose of today's CLE, is to really talk about the steward of our CAP program, Cathy James, who is a dedicated colleague on the bar staff. And so many of you are getting to meet her at today's CLE, and what a gift I will tell you that is for you and your practice and for your clients. Cathy has been such a vibrant part of what is offered to not only the legal community by way of expertise in the substantive and process skills of the law, but really an expert in how our clients and folks in the community experience the law, what it is that they struggle with, what it is that they're feeling, what it is that impacts our ability to really advocate on their behalf. And so today's CLE will hopefully serve as a reminder for you of how to build those skills, and how tremendously we need to pay attention to the nuances of our communication while we lawyer to individual clients, that there's a deep impact to the wider Utah community of how people experience the law, how people understand what lawyers do, and what Cathy does, not only to advocate for our clients, but really to advocate for the role of lawyers, to notice the value of a lawyer in a conflict situation. And so I am so honored to turn the time over to my good colleague and friend. I'm so thrilled we're featuring CAP as part of the Procrastinator series to reach a wide audience. I know many of you might be seeking MCLE credit through today's session, and that might be your impetus to join. We don't mind that either in June. We tolerate that as part of what we do. And we invite you now to know CAP and to improve our lawyering skills through Cathy's expertise. So Cathy, take it away.
All right, great. Thank you so much, Michelle. Thanks for that introduction. So yeah, today is a CLE where I'm going to make a presentation based on my experience of running this office. The CAP office was set up to take calls from the public, and it's from people I get calls from people who are calling because they have questions about their case or problems with their attorney or some combination thereof. And the basis for the presentation that I've put together is the conversations I've had with all the people who've called in, which I've done this job for 3 years, so it's over 1,000 calls, so a lot of calls. And I'm speaking, like Michelle said, not from an expertise in some area of the law, but from being thoroughly immersed in listening to people who call in and have problems. And we've described the CLE as, quote, being about building trust and relationships, listening with intention, trying to negotiate, communicate, and understand client needs. Ah, great. I am kind of a Luddite when it comes to the tech part of this, so I did manage to figure out how to move the slide. What I'm going to talk about today is not case law or statutes, or I'm not going to advocate for a certain legal argument. I want to focus on something that is crucial to the practice of law, but often flies under the radar because we are so concerned with what is the law, have we researched it enough, when is the deadline, trying to get all of that right. But mixed into that is the attorney-client relationship. And I found this quote by Justice Ginsburg: "A good lawyer knows the law. A great lawyer knows the people behind the law." And of course, being on the Supreme Court, that's on a grand scale, which is not where I'm operating. But still, I think that quote by Justice Ginsburg is getting at the kernel of what I am talking about, which is that interaction that goes on between the attorney and client. So, do you know your client? What is your client's story, and why is it important? It's quite possible that I'm not going to tell you anything you haven't heard before today, but I'm hoping that this presentation encourages you to just reflect on the attorney-client relationship and how you manage yours. and maybe think about ways that you could improve it based on hopefully an idea that you got from this presentation. So in the CAP office, what I'm hearing about are real life circumstances, personalities, sometimes unbelievably bad luck, and then the machinery of the law all interacting together that in a way that challenges the attorney and the client, and they've got to figure out how to proceed. And of course, people don't call me when things are going well. People call the CAP office because for whatever reason, they can't call their attorney anymore. Sometimes something has happened that's eroded their trust, or maybe the relationship has ended, but they're still in the middle of a problem. So I have a front row seat on how things go wrong. And I am basically receiving all this information and trying to figure out how to advise the caller. And one thing I began to notice, I've done this job for 3 years, is very often people thank me for listening. And I'm realizing often it's after people are heard and feel heard that they are ready to consider information I may suggest to them or directions I may point to them to try and resolve whatever the problem is that they've presented to me. So listening to their stories is important, I've begun to realize. And I wanted to begin with a very short story, which probably everybody has heard at some point. It was written centuries ago by anonymous, or haven't been able to locate an author. And of course, this story does contain a message, and the message is important. For want of a nail, the shoe was lost. For want of a shoe, the horse was lost. For want of the horse, the rider was lost. For want of a rider, the battle was lost. For want of a battle, the kingdom was lost. So small details this poem is telling us can have enormous consequences if we ignore them at our peril. But notice that this poem does something else. It engages your imagination. It's full of imagery. It may make you think of something that happened to you once upon a time. It makes your mind conjures images, and it engages you. It holds your attention. And just to prove my point, here is a summary of all that information that isn't packaged as a story. And I don't know about you, but if I have to choose between the two, I much prefer the poem to that dense paragraph. The paragraph doesn't hold my attention. So stories, for some reason, grab us and they're important. And I I wondered if there was research that supported this finding or this realization that I've had. And I did locate a study that was done at Stanford, just in a classroom, I think, by a professor. And it kind of bears this out, and it opens a window on how our brains work, I think. So the battle of story versus data. And in this experiment, classroom of students were given 60-second presentations, and they had to include data and statistics. And then after the 60-second presentation, audience recall was tested. The vast majority of these smart Stanford students decided to just present the data and statistics either in graphs or charts or whiteboards. 10% of the students chose to present the statistics via a story. And just fascinating, 63% of the audience remembered the information that came delivered in a story. 5%, and remember, 90% of the students were not using stories, but of all of those presentations, only 5% of the audience could remember the information. So that to me is a really powerful point. And the article that I was reading that shared this information noted that there wasn't even a correlation between how polished the speaker was As long as they packaged it in a story, the recall was better. So even a poorly delivered story wins over data. And so why do stories stick with us? Just to go over it again, we are emotionally engaged. Our brains seem to be able to process information more easily when the information is delivered in story format. And stories have structure and meaning. That may be one of the reasons that they are so helpful. Um, oh, I'm realizing. Can everybody still see the screen if I do that? This will help me because I'm losing track of what number I'm on. Um,
And Kathy, it's just in edit mode, but we can still see it.
okay. Um, yeah. So, so circling back, sorry for that pause. Um, I wanted to share on the topic of stories and why stories stick with us, a story that I've actually had in the CAP office. I'm gonna tell you the basic outline of it right now, and then I'll come back to it a little later in the presentation. So this is a conversation that took place probably almost 2 years ago. I answered the phone and I heard an agitated voice on the other end say, "I'm calling you to see if I can get my house back." And let's call the caller John. I was bewildered. "Can you tell me a little more?" And then I got a long explanation. It was my attorney's fault. We had a hearing and he didn't tell me about it. We missed the pretrial hearing and my sister Eva got a default judgment. And if we hadn't had that hearing, then I would have been able to tell my story to the judge. But then the lawyer made a stipulation and agreed that I would buy my sister out. And the attorney got me a loan with a private lender. But then COVID hit and I lost my job and I couldn't make the payment, and the lender paid my sister and put the house up for sale. But I never signed the stipulation. I never even saw it. Eva made a verbal contract that she wouldn't sell the house. And in Utah, you can have a verbal contract, can't you? All I wanted to do was tell the judge my side of the story. I know I might not have won, but all I wanted was my day in court. And my son is 14 and he needs a home to live in, and now we don't have one. So that really struck me and it was tragic. And not only was there nothing I can do, and it happened like 8 years ago, um, but it stuck with me because of the loss that the man had experienced, and also because of what I was hearing about the sequence of how things had happened. Um, it's hard to know in retrospect what could have or should have been done differently, but this story made me wonder, was there something that the lawyer maybe should have heard or listened to in speaking with John that might have allowed things to go differently after that missed hearing before the stipulation was made? So that's a story that I wanted to share, and I'll come back to it. Um, what do stories have to do with lawyering? As I've been pointing out, um, they have to do with communication. Um, that is kind of the broad introduction of this presentation. Um, and now what I want to do is kind of take a deeper dive into this idea of what communication is and look at it from a couple of different angles. So we're looking at the attorney-client relationship. It's a small piece of the picture, but a very important one. And good communication lies at the heart of a good attorney-client relationship. And what I want to do now is I've split the rest of the presentation into three different parts, three approaches to communication. What is it? And I'm going to look at it from three different angles. Why, how does it play out in our lawyering relationships? And then with that understanding, how can we apply it to improve the communication between attorneys and clients. So what is it? It's a professional obligation. And there's one rule in particular that I'll just pull up here. And I just wanted to review what are the verbs that we're asked to do here: inform, consult, keep the client informed, promptly comply, and there's another consult, and then explain or educate. And the rule covers different kinds of information, but clearly it's fundamental to keeping the client happy. And as I read this, though, I realized there is something missing here. I was surprised that nothing is mentioned in here. The one thing that is not mentioned in our rule, and I'm wondering if this maybe even indicates a professional blind spot, there's nothing said about listening to the client. So there's a lot of attention paid to what the attorney is saying, but nothing in this rule draws our attention to the client and the need to listen to the client's part of the story. I think it's interesting that it's not in there, and we'll come back to that. But anyway, we have it as a professional obligation. All right, now I want to show a video that it picks up the second part of communication that I want to look at, which is communication as a complex process. And my point here is that we are all operating with the same basic equipment, attorneys and clients alike, which is our senses and our brains. And of course, there's massive variation in individual attributes like level of education, emotional intelligence, experience, personal history. But even in spite of all those differences, we share a lot of the same limitations and operating equipment, basically, so to speak. So now I am going to see if I can actually get to, there we go, a video that I want to show. Oh boy. All right. Can you see this screen, everybody?
Yes.
Okay. So this will kind of orient us to what we're all working with in terms of our senses and how we exist in the world. It's only 3 minutes. I think it's fairly entertaining. I'm going to try and make it start at exactly where it begins instead of the advertising. Okay, here we go.
www.grahamfranks.com. One question that conscious leaders ask themselves over and over is, where am I? To support leaders in locating themselves as they ask the question, where am I? We offer this tool, a line, a simple black line. At any moment, all leaders and all people are either above the line or below the line. Our location describes how we're being with what is occurring in our life right now. If we're above the line, we are open, curious, and committed to learning. If we are below the line, we are closed, defensive, and committed to being right. Stop right now and simply ask yourself, where am I? In this now moment, am I above the line or below the line? Typically, when people are below the line, they believe certain things about the world. For example, they believe there is not enough. It could be that there's not enough money, or time, or space, or energy, or love. People below the line also believe that their story about the situation is right. People below the line also believe that there is a threat out there. Something or someone is threatening their desire for approval, control, or security. And people below the line see the situation as serious. The deeper below the line they are, the more serious things look. People below the line tend to behave certain ways as well. They tend to cling to an opinion, find fault and blame, gossip, explain, rationalize and justify, get overwhelmed, and avoid conflict or pursue conflict for the sake of winning. When people are above the line, they believe that learning and growing are more important than being right. They believe that all people and circumstances are their allies, here for their growth. They believe that from a distance, almost everything is funny. People above the line live in curiosity, listen deeply, speak unarguably, question all their beliefs, and live a life of play. Now, knowing what you know about being above or below the line, where are you? One thing to know as you consider this question: we are hardwired to go below the line. Literally, our brain is programmed to perceive threat, and when it does, a chemical cocktail courses through our veins, and we go below the line. This reaction was designed to help us survive in the presence of a real threat to our physical survival. An issue for modern-day leaders is that often our brains can't tell the difference between a threat to our physical survival and a threat to our ego or identity. We react and get defensive when we experience a threat to our ego. So in many ways, being below the line is natural and normal. But when we are below the line, we're not in a state, literally brain state, of high creativity, collaboration, innovation, and relational connection. We're simply trying to survive. Leaders today can't thrive if they're in survival mode. So the first activity of conscious leadership is location, location, location. In this now moment, where am I? Telling ourselves and others the truth about our current location begins the great conversation.
Okay, are we back on the screen? No.
There you go. Perfect.
There we go. And it would be nice. Oh, well. Would like to make this a little bit bigger, but oh well. So what that video did that I thought was so interesting is allow us to think about not only where we are, but where is our client. And most likely, most clients come in under the line because they're dealing with a problem. And I think that the attorney-client relationship and the communication, if it's good, that can happen, can be one of the things that helps push a client and maybe the attorney as well into a better place so that the communication that does happen is more effective. They're not defensive, they're not below the line, and mostly concerned about protecting themselves. And that video also I thought was interesting because it's an illustration of all the ways that things that we don't really control can affect us as we communicate. Psychological and social influences, the biological and neurological factors, sensory perception. I ran across and decided not to use a short clip that talks about how our brains process auditory information. And as a result of radio operators back in World War II having to take in a lot of information at the same time, some studies were done because people wanted to understand how do our brains actually process the sounds that are coming in through our ears. And it's been well established that in an array of multiple sounds, our brains will focus on signal strength, and we can only process one sound at a time. So even if we think two things are coming in at once, that's not the case. They're coming in, our brain is sorting them in one at a time. So, just sort of system operating features that we all share. None of us can hear multiple things all at once. All of our brains are going to take in one thing at a time. Another really interesting thing that affects communication is the power and status of the speaker and the listener, of the two people who are interacting. And examples of that, are easy to come up with. In a law firm, the first year, can't remember, associate or the managing partner. But those relationships are throughout society. A CEO carries a different weight than the first year intern, teacher student, parent child. And when it comes to attorney client relationships, attorneys almost uniformly, when people are talking to me in the CAP office, attorneys have a lot of power and status. And I've more than once had people ask me, can I fire my attorney? So they are not even, would they ever ask, can I fire my plumber? No. So there's something about the status that an attorney has that definitely affects the relationship between the attorney and client, and quite probably the communication. And then finally, culture and language, which are in many ways invisible to us because we're immersed in our own cultures, so we don't necessarily see how culture affects us. And I found it really there's thousands of examples of cultural influence, but I was just going to share one that I found that was quite interesting. It was described by an anthropologist named Edward Hall, and he came up with the terms low context culture and high context culture to describe how communication styles differ across culture. In essence, in low context cultures, meaning is expressed through explicit verbal messages, both written and oral. And of course, legal culture is an example of that. We were very focused on the words and the message. And in contrast, a high context culture, in those societies and cultures, intention or meaning is often best conveyed not through words or direct messaging, but through implicit context, gesture, social custom, silence, just not saying anything, nuance, or tone of voice. And I included a little slide here of nations that are on the extreme ends, Switzerland being a low context culture, and the United States also trending in that direction, versus Japan on the other end, and the UAE. So just something to remember, all of these invisible forces that we don't necessarily control and we're not even really aware of half the time are affecting our communication. And then I also wanted to take a look, the last what of communication that I wanted to look at is communication as action. That's just super simple. Somebody's speaking and somebody's listening. Transmitting the message, receiving the message equals communication. But the point I want to make here is the underappreciated side of that equation, which is receiving the message or listening. And I loved these two quotes: knowledge speaks, but wisdom listened, Jimi Hendrix. And the word listen contains the same letters as the word silent. That never occurred to me before, but really interesting that there's that correspondence. So communication is action, speaking and listening. And clearly, lawyers, I wanted to look now about how we are trained as lawyers. We're trained to look at the facts over emotion. And I've referenced here the points from this section. I drew a lot from an article called The Heart of Lawyering, Clients, Empathy, and Compassion that was written by Catherine Gertie, who is, I think, still teaching at BYU. But it's an excellent article. And so, yes, lawyers are really sometimes, well, we vastly overestimate the importance of logic and reason. And they are important, but they're only one piece of the puzzle. And again, many lawyers view the practice of law as a set of legal problems to be solved, not so much a vocation which assists people who have problems that involve both factual and emotional dimensions. And I wanted to share, because I just think it's so powerful, a quote that talks about the role of imagination in lawyering. It comes from a University of Chicago Review article by a woman named, I think she's a professor, Martha Nussbaum. So here is her take on the importance of imagination. The imagination of human distress, fear, anger, and overwhelming grief is an important attribute of the law. Lawyers need their imagination to understand and effectively depict the plight of their clients. Judges need it to sort out the claims in the cases before them. Lawyers advising corporations need it in order to develop a complete picture of the likely consequences of various policy choices for the lives of consumers, workers, and the public at large, including the public in distant countries where corporations do business. Factual knowledge is crucial, and in its absence, the imagination can often steer us wrong. But knowledge is also inert without the ability to make situations real inside yourself and to understand their human meaning. So listening is, it's not emphasized. We're trained to emphasize speaking over listening. And what I've come to understand in the CAP office is that the direct consequence of me listening to somebody is that they feel heard. Wow, I don't know why this has not come through in the screen, but it's what it says here is listening is a hugely important component of the active communication in the attorney-client relationship. And it's because feeling heard and understood really helps establish a foundation of trust. And active listening involves not formulating your answer while the person is talking. It means quieting your mind so that you can really pay attention to what somebody is saying. And I ran across a study that came up with the idea that there are 5 elements that you have to have in place in order to feel heard. And I think it's more accurate to say this is not just feeling heard, these are also prerequisites to real and true listening, not just hearing something, but actually understanding. So I just wanted to briefly go over these parts. Voice refers to the person who is speaking, and that person has to feel as though they have the psychological permission to speak freely. They can't feel constrained. They can't be scared, which is often, clients tell me they're scared of the lawyers. So they have to, you want to not have fear. You don't want to be below the line, referring back to the video. Then on the part of the listener, attention. Attention means you are present to what I say, not half listening while you are planning how you're going to respond. Empathy means you are making a genuine effort to see things through the eyes of the person who's speaking. Respect, that you take that speaker seriously as a person worth listening to, even if you don't agree with what they're expressing. And then take all of those things together, and that can give you some common ground for which to move forward from together. And in my experience, it's really important that people feel heard. It's important before they can entertain other ideas. They have to say their piece. So lawyering is a delicate balance between these two things. You need your compassion and your intellect, your heart and your head. And as I was reading through these 5 elements of being heard, I wanted to share, there was an example in the article of how listening and feeling heard can be transformational. And it was this example. Jimmy Carter at the Camp David Accords in 1978. There was a meeting between Anwar Sadat and Israel's Menachem Begin. Carter's approach was not tactical negotiation. It was deep, heartfelt listening. Sadat later said he did not lecture us, he let us be heard, and in being heard, we changed. So listening as a prerequisite to allowing somebody to let go of how tightly they're holding on to their story in order to entertain other possibilities. So thinking back to the video that we just watched, it's my impression that listening and active listening, letting your client be heard, might be a crucial piece in explaining, educating your client so that they can let go of their preconceived notions and move forward in a direction that will work for them and the lawyer. Okay. So that is the last part of the what that I wanted to look at, professional obligation, a process and an action of communication. Now I want to turn to the why. Why is it important? I see that there's a lot of comments in the chat, and I'm sorry I'm not going to take time to look at it, but I'm sorry if I'm not responding to questions. So I've given you a lot of anecdotal evidence that communication is important, but it occurred to me, is there research out there? What's the evidence for this actually? And I did come across, it's not a heavily researched topic, but there were some significant findings, and I wanted to share those with you. I ran across a really short but succinct and relevant article by an attorney named Philip Hadlock, who worked for 40 years at the United Nations, the U.S. Department of State, and the USDA. And he currently runs an online journal called The Attorney's Voice. You can look this article up if you want. And he wrote an article called The Attorney-Client Relationship, a Communication Perspective. And I've shared the findings of this article with you. And he's mentioning a study that was done by the ABA on that profiled legal malpractice claims, 20 to 23. And 10% of malpractice claims stem from the poor application of the law. So it sounds like as lawyers, we do a pretty good job of getting the law right. That's not a high percentage, 10%. The remaining 90% results from poor communication with clients. I thought that was quite staggering. 90% of malpractice claims coming from poor communication. So that's a study that reinforces this notion of, yeah, it actually really is important to client. And certainly from my perspective, I hear about it a lot. I also wanted to share some findings. I did a short presentation in April at the ethics school that the OPC puts on. And I realized I had an opportunity to survey lawyers who were attending it. And so I wrote up a survey because I wanted to find out how attorneys see these things. And I asked, the first question was asking attorneys to rank the issues and problems in terms of how often they occur in your practice. And unfortunately, I had another category, but then it didn't become part of this bar graph. But interestingly, loss of trust was the highest. It was the thing that occurred most often, or what they found most problematic in their practice. And then the second was language barriers. And then the third was communication. So even attorneys in Utah, substantiate this, that communication is really, really important. And we're, commenting that they had trouble with it themselves. And I did a little hand-drawn flow chart here. A lawyer's skill at uncovering and understanding her client's story and needs can lay the foundation for the trust that needs to be built. And now I want to go back to some more stories from the CAP office because I think they can help consolidate some of the information that I have been sharing here. So I think I've already spoken enough about the story of John and the loss of the house, and my suspicion that maybe there was something going on if there had been an interaction between the attorney and I'm not sure that the attorney and John ever actually met in person, but I'm wondering if something got missed by the attorney. A second story I want to tell is something that's come to my attention, and it has to do with plea deals. And I get a fair number of calls from people who are criminal defendants who have complaints or concerns or frustrations that they mention about their defense attorney. And in the area of plea deals, this theme comes up again and again and again. And it's also an area where I've drawn this conclusion that the client needs to be heard and isn't necessarily being heard by the attorney. So what happens is I'll get calls from criminal defendants, and I'm going to just talk about it in terms of a single person. So I had a call from somebody who I'll call Thomas, who had some serious felony charges. It might have even been in federal court. Like they were not good. And the defense attorney had negotiated a plea deal that had substantially reduced the client's exposure to a long jail term. And Thomas, however, did not regard this as a good thing. He was fit to be tied. And he was calling me to complain and ask if I would talk to the attorney. And I realized that there was so much emotional weight and urgency in Thomas's call that I just decided, okay, I'm just going to listen to the story. And I listened to him explain why he didn't want to take the plea deal and how so much of the evidence wasn't really convincing. I mean, he had all these arguments for why it was silly for him to take a plea deal. I listened to that, and it was only after listening to it that Thomas kind of calmed down. And I had an opportunity to start to talk to Thomas about why the defense attorney might think that it, nevertheless, even if Thomas was innocent, a plea deal might be better. And so I tried to walk Thomas through the idea that while it's his case, he's only had one of them, the attorney has had many, many cases, and the attorney's strategy is going to be informed by his or her experience of how these things go. And one of the things about a plea deal is it's like a bird in the hand is worth two in the bush. You, at least with a plea deal, know what you're getting. You can't make any guarantees if you decide to go to trial and if you give up the plea deal. And I know that when I have spoken with defense attorneys, they find this issue really frustrating in terms of clients not understanding this. So anyway, this was an instance where I was able to persuade Thomas to at least give the attorney an opportunity to explain his thinking about why the plea might be a better choice, even though the final decision would still belong to Thomas. And I had the impression that it was only because I listened to Thomas that he was then willing to entertain the idea of listening to his attorney. So again, this notion that being heard can be kind of transformational. And one more illustration of this. My last topic down here is easements, which is kind of unusual. I don't get that many calls about easements, but I realized when I do, they seem to all follow the same pattern. And I thought you would be interested to hear about this. I have observed that when I get a call from somebody with an easement problem, I can anticipate that not only are they arguing with their neighbor, but they are also very frequently arguing with their attorney about the very easement problem that they hired the attorney to solve, which is kind of odd. And it's just striking how this pattern repeats. And so I'll describe to you what happens. The client hires the attorney to help them with a contested easement. And invariably, it seems, the client has a really strong idea of what the easement is, where it is. I mean, the client is incredibly biased in terms of thinking that they're right about their easement, right? And this translates to them thinking, well, I'll hire an attorney and the attorney will do what I tell them to do. And they believe it's just simply a matter of the attorney parroting the client's explanation of why their easement, you know, why their interpretation of their easement is the valid one. The attorney, however, thinking back to earlier in this presentation, the attorney isn't going to take the client's word for it. The attorney is going to be diligent, going to be competent, and absolutely not going to take the client's word for it, but instead do her own research, looking at titles, history, recorded documents, et cetera, et cetera. And research into easements is really time consuming. I mean, they're complicated. They can be complicated. So 3 different times when this was the issue, the case never even got to the point, like when these people were calling me, the easement was still being fought over, like it hadn't resolved. And yet a dispute about fees between the client and attorney had erupted. And the client complains that this is just a simple easement. And the attorney who has undertaken hours of research trying to be careful and thorough, is viewed by the client as just being a profligate time and money waster. And I was stumped by this for a really long time because I, being a lawyer, was inherently understanding this from the lawyer's point of view and just thinking, well, you have to research this. And then all you have to do is explain it to the client. But uniformly, something is operating in the client that has nothing to do with the actual answer to the easement question. So I've realized here, and right now I just have an operational theory because I can't prove it, but I'm thinking that in these instances with easements, what the attorney has failed to grasp is some piece of the client's story that is underlying the easement problem. And that until the attorney has sufficiently listened to how the client sees things, the attorney doesn't stand a chance of convincing the client that all of the hours the attorney spent were actually worth it. So I'm hoping that I get more calls about easements because I don't think I've gotten to the bottom of this, but my sense is there's a missing piece here, and I think it has to do with some aspect. It could be fear on the client's part. It could be that the client is worried about ultimately about the value of property, depending on the outcome of the easement question. Anyway, something is operating here, and I'm not sure what it is, but I think it has something to do with listening to the client's story. So those are some more stories from the CAP office that I hope are interesting illustrations of this, of the reason we need to listen to what our clients have to say. Because we're going to uncover something that without listening to them, we can't know. So, all right, that's the why of why stories are important. And now finally, what do we do with all of this information? How do we put it all into practice? This is the shortest part of my presentation. And I just have a couple of different slides kind of putting together ideas about how can we bring this to our attention and try and make this habit. So I came up with 9 just sort of rules of thumb, and they reflect, I think, what I hear people complain about most. And a lot of these have to do with communication. Clients want to be heard. So let them know you've heard them. You not only have to listen, but you have to reflect back what you heard them say. That's part of them feeling heard. In terms of communication about the cost of services, bills with no explanation of how the time was spent. And many attorneys are very conscientious and break everything down, but I seem to encounter the clients whose attorneys don't do that. And it's mystifying to, look at a charge of several $1,000s and just have a little one-liner about how it was spent. So explain adequately. Delivery counts. And, now I'm thinking of the the standards of civility and professionalism. We got to be nice because clients are already thinking back to the point that I made about power and status. They are already in the lower position and they can truly fear their attorney. And when attorneys are rude, sarcastic, yell, get angry, it just really sends the relationship south. The next two, lack of preparation and surprise, they're kind of two sides of the same coin. You have to prepare your client for what to expect. And if the client needs to come to a hearing prepared, don't tell them the night before. They need time just like you do. Communicate the essentials. And then regular updates, thinking back to the actual Rule 1.4, you have to communicate regularly. This is a huge reason that people get frustrated with attorneys that I hear about. Months go by from that I've heard about where callers have not heard from their attorneys. And, of course, I almost always say, well, they're juggling a lot of cases, but still regular communication. If you get a question, respond or tell them when you're going to respond. And another area where communication often just doesn't seem to work between the attorney and client is if, from the attorney's point of view, it's not really urgent, like nothing's been filed yet. But from the client's point of view, it's their case and they want action right now. Either be prompt, or if you can't be prompt, have a good explanation for when you're going to start and then stick to it. And then finally, if you make a promise, keep your word. I do find that clients are pretty forgiving if the attorney owns up to making a mistake or, dropping the ball. But a chronic repeated pattern of that kind of thing will really affect the attorney-client relationship. So bottom line, failure to keep these really fairly simple obligations will erode the client's trust. And I've made a suggestion that you can use a checklist. Going back to the survey that I did of the attorneys at the CLE this spring, I had a series of open-ended questions. One of them was, what makes a good attorney-client relationship? The word communication was used 74 times out of 121 replies. There were 154 people, but not everybody answered this particular question. And 88 of the responses to that question referred to communication indirectly. So 72% of Utah attorneys who answered the question did reference communication as far as what's necessary for a good attorney-client relationship. And then other features that were mentioned: honesty, transparency, regular contact. These are all things that were above. Setting reasonable expectations, respect, and trust. And then I wanted to reprint an answer that came from a single, nobody attached their name to this, so I don't know who it was, but it was full of wise observations, and I thought I would share it to you. It's from one of your colleagues. What builds a good attorney-client relationship? Frequent and honest communication. Being straightforward and honest. If I ever tried to soften the blow of bad news or adverse law, it always led to an unhappy client. Instead, being just a tiny bit pessimistic with a client allowed me to underpromise and overdeliver. instead of being the other way around. Another, I think, really important substantive point about communication, biting the bullet as soon as it is there. In my experience, this is me quoting the attorney. In my experience, difficult conversations in uncomfortable positions don't get better with time. Having difficult conversations sooner before problems have time to ferment usually makes the situation better. If I make a mistake, I own up to it quickly and correct it. Extremely important. So important to, if you made a mistake, say so and apologize. I can't emphasize that strongly enough. That really impresses clients that I talk to. Treating clients like they are more intelligent than I am, or at least not stupider than you are. They are smart enough and don't buy excuses. So I shared those because it was just so heartfelt and so full of good advice. And finally, I just want to call your attention to a great book called The Checklist Manifesto, How to Get Things Right. It's written by a surgeon, and it's about how checklists can help you systematize basic things you need to get right all the time. Because in this complex society that we live in, it's pretty easy to forget things, and a checklist will help you remember. So I highly recommend that book, but that could be a way of just incorporating better communication habits into your practice. So I'm going to wrap up here. I have a final slide, but I want to make a couple of observations. It's interesting. We have all these ways of communication right now. We have emails, we have texts, we have Zoom calls where I can't see any of you right now. That may partly be due to the screen, but it's kind of an odd sensation. So in spite of all these modes of communication, poor communication, according to the research I presented to you, is still plaguing us. So how can that be? I've tried to supply you today with some convincing evidence that paying attention to communicating with your client and how we communicate, and especially how we listen and empathize with the client, can have a profound impact on our practice of the law and improve things for both the attorney and the client. And I think one of the implicit points that I'm making, oh, wow, it's 1 o'clock. I'm sorry, I've gone overtime. I'll just try and wrap up really quickly. I was paying attention to my own timer. Communicating in person just can't be replaced. And if you can't meet face to face, talk on the phone, because then at least you can hear the tone in the client's voice. So to wrap things up, and thank you for your patience as I go over time, listen to the story. It might just be the nail that keeps the shoe on, that allows the horse to gallop, that gives the rider a mount, and so wins the battle and saves the kingdom. Thank you all very much for your attention. I hope this was interesting and that you've got something to think about. I'm done.
It was wonderful, Cathy. Thank you. Not to worry for going slightly over. We were just past the noon hour when we began, so we're in great shape. And
Okay.
thanks to all who joined. You would be impressed, Cathy. The chat was actually deeply engaging, so we'll do our best to get a copy of that to you so that
Oh,
you
awesome.
can see how much your colleagues enjoyed and engaged with the dialogue back and forth. There were not questions that were ignored, so you're in good shape that way. And we look forward to communicating with everyone and sharing your slides. If you're willing to share them with CLE, we can distribute them to your colleagues who joined you.
Okay, I will. Sorry
Tremendous.
to have that ready. Thank you, everybody.
Take good care, everyone.